On the phone, ladies and gentlemen, it is a pleasure to welcome this man back to the program. He has been studying, reporting on, and examining the Voting Rights Act for the past, I don't know, it feels like at least 3 or 4 years, and I know how hard you've been working on this basically since your last book. And today is the day the book comes out. Ladies and gentlemen, Ari Berman, his book, Give Us the Ballot, The Modern Struggle for Voting Rights. Welcome back to the program, Ari.
Hey, Sam. Thanks for having me. And you have the first interview with me since the book is out. You are basically the Charlie Rose of podcasting.
Wow. I appreciate that. This is big. I mean, this is almost
Hopefully
like,
you don't talk over me the whole time and bang your arm on the table.
That's going to happen. I'm almost like the Mark Maron of podcasting. Almost.
Yeah, well, that is actually sort of true.
I know you couldn't
You're
get
the Mark Maron of liberal, liberal and I would say humorous podcasting.
Oh, well, thank you. I appreciate that.
I was going to say not humorous, but then that would be too insulting. So.
Well, Ari, you're too kind to say that. We have a link at Majority FM, and we're going to tweet out, obviously, your book. I should say Maron is liberal and mildly amusing, but he doesn't espouse much politics these days. So Ari, all right, let's dig into this. I mean, you and I have talked many times over the years over what has happened to the voting rights. Let me just back up a minute and get a sense of did you begin to dig into this stuff in the depth in which you have before or after the Supreme Court basically gutted the Voting Rights Act?
Well, the answer is both before and after. Not to hedge, but I started reporting on it well before the Supreme Court gutted the Voting Rights Act, because I started reporting on voting rights in 2011 when all these new voting restrictions started being introduced. So when we saw Florida shut down voter registration drives and cut early voting, when we saw Ohio cut early voting, when we saw a ton of states, Texas, Wisconsin, Pennsylvania, etc., pass voter ID laws, we saw an unprecedented number of new laws being introduced to make it harder to vote. And I first reported on that, first for Rolling Stone and then for The Nation. So I was doing that first, just covering the current attack on voting rights all the way through the 2012 election. Then, once there was a challenge to the Voting Rights Act, I became very interested in the history. And I wanted to know what the Voting Rights Act did and why it was being challenged. And I kind of asked around and said, to voting rights experts and other people, and said, what should I read to get up to speed on the Voting Rights Act? And there wasn't really a good answer. I mean, there was like a lot of obscure law review articles out there, and I was like, well, someone needs to tell this story. Kind of anticipating the Supreme Court was going to gut the Voting Rights Act in anticipation of the 50th anniversary of the VRA, which is on Thursday. And so I basically thought, I'm going to write a book that talks about both what the Voting Rights Act did, so people can appreciate this, because it's just such a massive story. But I was also going to talk about the 5-decade backlash to the VRA, so people could understand not only why the Voting Rights Act was being challenged, but why there's this whole push post-Obama's election to make it harder to vote.
And we should say, well, all right, well, we'll get to I guess the sort of the premise, or the false premise is probably more accurate as to why these voting restrictions were put in. So let's go back to the passage of the Voting Rights Act, because in many ways your book starts where, for people who saw Selma, where Selma ends in some respects, right?
Yeah.
You are talking about the wake of the or I should say, what happens in the wake of the passage of the Voting Rights Act, and it's a rather long wake, and in some ways, it's actually sort of getting more tumultuous as time goes on, or maybe, I don't know, at both ends of that sort of the curve, and we're obviously not at the end of it.
Yeah.
But tell us, like, what were there's two sets of implications, really, broadly speaking, right, to the Voting Rights Act. That is what it meant for people whose whose voting rights had been denied, and what
Yeah.
it meant for people who had been basically denying those voting rights.
Yeah. So, I mean, you're absolutely right. I wanted to start where Selma ended, and I obviously started reporting on my book well before I even knew there was a Selma movie coming out. But I basically knew that, almost all the accounts of the civil rights movement and the voting rights movement ended with Selma in 1965, not with the movie, but with the march as the kind of pinnacle of the civil rights movement. Or they ended in 1968 with the death of Martin Luther King as the kind of demise of the movement. And I knew that wasn't the story, that the whole story is that the civil rights movement didn't end in 65 or 68, and that the battle over voting rights certainly didn't end in 65, that a whole new battle begun after the VRA was passed. And that was really the story that I wanted to tell in the book that I thought nobody had told before. And so what it meant was that millions of new people were brought into the political process, not just African American voters who were the initial subject of the law in terms of getting all these disenfranchised voters registered, but the law was expanded to include Latinos, Asian Americans, other language minority groups. Through the reauthorizations of the VRA, the voting age was lowered to 18. Literacy tests and poll taxes were abolished across the country. So this was a law that expanded voting rights for all people, and the Voting Rights Act was reauthorized 4 times. And that really became the prime vehicle for expanding voting rights for all Americans. So it was a really, really, really consequential law, one of the most consequential laws of the 20th century and into the 21st century. And what it also meant is that those people whose power was taken away, the old white segregationists, they had to rebrand basically. And what happened is a lot of them did rebrand with Nixon's Southern strategy, and people like Strom Thurmond, for example, became very influential in the Republican Party. And then what you saw is a whole new generation of civil rights critics rose, first through the Reagan years and then in the Bush 2 years. So you had a whole new generation of people coming up. They weren't necessarily motivated by racism. They were either motivated by ideology or partisan politics or any number of things, but you had a whole new generation of what I call counter-revolutionaries. And they came up not necessarily from the 60s, but they really started to gain power with the Reagan administration in the 80s, and then again they got a foothold in the Bush 2 years, and that laid the groundwork for what we saw during the Obama years, when people have introduced all these new voting restrictions and also gutted the Voting Rights Act.
Now, when this when that counter-revolution happens, is that at what point did they land upon the idea that our votes are insecure? I mean,
The voter fraud part of it,
yes,
you mean?
Yes.
Yeah, so can I just kind of walk through quickly the different stages of the counter-revolution, because I think it's important for people to understand them. So, I mean, at first you basically have states making a states' rights argument. In 1965, after the Voting Rights Act passed, Alabama, Mississippi, et cetera, basically say the federal government doesn't have the power to govern voting rules. And very quickly, which is the argument they had made for like 100 years after the passage of the 13th, 14th, and 15th Amendment, and very quickly the Supreme Court says, no, that's totally wrong, that the Voting Rights Act was passed precisely because the federal government has the power to enforce voting rules in the South because they've been ignored for so long. So that argument goes out the window, and what you start seeing is this rebranding of opposition to civil rights in terms of colorblindness. And
now let me stop you there 1 second there, Ari, because I want to make this clear to people. There is no constitutional right per se to vote, is there? I mean, I know that there is a constitutional right for the federal government to ensure the way that some uniformity, I guess, with federal elections.
But here's what you have to understand. The Voting Rights Act just enforced the 15th Amendment, which bans racial discrimination in voting. So when states were saying the federal government can't come in and register voters or outlaw literacy tests, the Supreme Court said, yes, they can, because these things violate the 15th Amendment. And the VRA was meant to end 95 years of disregard to the 15th Amendment. So the Supreme Court wasn't saying there's a fundamental right in the Constitution to vote. They were saying there's a fundamental right to vote free of racial discrimination, which is what the Voting Rights Act was meant to do.
Okay, so just so that's clear for people where that authority comes from, it doesn't come from actually the vote. It comes from basically anti-discrimination laws. Yes,
yeah. And we've never passed a constitutional amendment or anything like that saying you can't make it harder to vote or you can't make any qualification on voting. We've never done that. I think that's one of the reasons why the vote has been so contested over the years, because there isn't that fundamental protection. But anyway, the next phase of opposition to civil rights, what you really see in the Reagan years is this idea that, historic remedies to voting discrimination, historic remedies to discrimination lead to more discrimination. So the argument against quotas, affirmative action, busing, they're trying to make the argument that the Voting Rights Act will lead to all these forms of affirmative action in the electoral sphere. And they're saying that, for example, when you draw a district that leads to a black candidate getting elected or a Hispanic candidate getting elected, that leads to affirmative action. And that was in the electoral sphere. And that was an argument that the Reagan administration made super aggressively and was very influential. And then what you saw...
I want to stop right here, too. That's the argument, it seems to me, that Scalia makes in the case that Guts. I mean, he at one point talks about how there's this creeping sort of, I guess, special privilege being awarded to minorities.
Yeah, and I mean when Scalia during the Voting Rights Act case says that the VRA has led to the quote unquote perpetuation of racial entitlement,
right.
He is making the most blunt and crass version of that argument. But it's an argument that's not just being made by Scalia; it's being made by John Roberts and a lot of other people, Sam Alito, that are appointed to the court. So the next thing you see is in the Bush administration, the Bush II administration, because the Bush I administration was actually pretty good on some of this stuff, but the Bush II administration, they come in and they start banging the drums on voter fraud very, very aggressively. And I lay out this whole story in my Nation excerpt that ran last week called how the 2000 election in Florida led to a new wave of voter disenfranchisement. Because basically, as a result of what happened in Florida, as a result of what happened in St. Louis in 2000, you get all these people in there from the Bush administration who are obsessed with voter fraud, believe it's rampant, and are supporting new measures like voter ID laws to try to make it harder to vote under the guise of cracking down on voter fraud. So the massive emphasis on fraud that we've seen in the Obama era began during the Bush administration.
And that was that von Spakovsky?
Von Spakovsky. Yeah, I mean, it was him. Basically, what happened is, so I'll just sort of tell two stories. I mean, one story is that there was this massive voter purge in Florida in 2000. Thousands of people were wrongly labeled as felons. They were disproportionately African American. They were purged from the voting rolls in 2000. Thousands of them. Very, very possible that could have cost Al Gore the election. I mean, it was 22 times. The number of voters that were purged from the rolls was 22 times higher than Bush's margin of victory. So this was a huge undercovered story in 2000 and into the day and into today. And I think, that convinced a lot of Republicans that these small manipulations in the electoral process could have a really big impact in deciding close elections. The second thing is that, in the 2000 election in St. Louis, all these voter registration cards are mailed out to voters. And basically any card that's returned as, undeliverable or address not delivered, et cetera, these voters are just purged from the voting rolls like in Florida without being notified. So you have like 50,000 people in St. Louis who are purged from the voting rolls without being notified. What happens is all those people show up to vote. They're not able to vote in the St. Louis election in 2000. They're sent back to the Board of Elections. It's a total nightmare. In any case, the larger context here is that John Ashcroft at that time is running for re-election to the Senate against Mel Carnahan, who dies 3 weeks before the election. Carnahan's wife runs against Ashcroft instead. A judge in St. Louis orders the polls kept open a few hours longer because there's so much confusion from all these people being purged from the rolls. The Bush campaign challenges that. The polls are closed after 45 minutes. Ashcroft then loses the election, and basically St. Louis Republicans believe that the election is stolen, that Ashcroft lost to a dead man, like in 1960 Chicago, because all these people were illegitimately allowed to vote during the extra hours. There's no evidence that actually happened, but what you see is that after Ashcroft loses that election, he's appointed as Attorney General in the Bush administration. And under Ashcroft, all these new conservative ideologues come in and they're obsessed with voter fraud, and Ashcroft gives them the go-ahead to pursue it.
And beyond that, this was also part of a broader scandal with the firing of these U.S. attorneys, right? That Rove ostensibly was involved in making sure that people were pressing these questions of voter fraud as the predicate for introducing things like voter ID.
Yeah, absolutely. I mean, you saw this at the highest levels of the White House, and you also saw U.S. attorneys who were fired for not aggressively prosecuting voter fraud. So there was just this huge emphasis on voter fraud. They never actually found any voter fraud. The Justice Department did a huge investigation, didn't find any cases of voters going to the polls and impersonating another voter that would have been stopped by voter ID laws. The U.S. attorneys that were fired were Republican U.S. attorneys who said that they just didn't have any evidence to prosecute these voter fraud cases. So you see a huge amount of hype, but actually no evidence. And that's the same kind of thing we're seeing in some ways on steroids in the Obama years, which is just these insane accusations being thrown around all the time about voter fraud. But when you look closely, very little to no evidence that the fraud is actually occurring.
We got a guy who calls this show regularly, convinced that the absence of these voter ID laws have opened the door for undocumented immigrants to vote en masse, of course, to sway elections. And
I'm just waiting for Donald Trump to start making that argument.
Well, I mean, I think it's coming, right? I mean, because now
I'm sure it's coming.
This is an argument that has efficacy across the board. So,
and it's almost like Donald Rumsfeld's. Like, remember when he said that evidence of absence is not absence. Wait, absence of evidence is not evidence of absence.
Right.
In talking about the lack of WMDs in Iraq.
Right. Well,
that's kind of like what it is like with voter fraud. You say, well, you talk to them and you say, well, there's actually no evidence of voter fraud. They say, well, how do we know if we don't have these laws? So like they're almost like they're basically nothing you can do can convince them that the fraud is not occurring.
And I don't know. I imagine if there was that many undocumented immigrants who were bold enough to come in and change the outcome of an election for, I don't know if they feel they could do it for the presidency, maybe, but maybe for like the county comptroller or something.
Why would any undocumented immigrant who's trying to avoid, being caught, is just here to work? Why would they risk it by voting when you get so little in return many times for that vote? I mean, it makes no sense.
I think if you can go home and tell your kids that you have materially affected the outcome of the comptroller race, I think that's probably a source of pride. I mean,
sure. I mean, those comptroller races in Arizona, I mean, they get pretty heated.
They can. All right. Well, so let's talk a little bit about. I'm also curious what happened on the sort of the activist side after the passage of the voting rights. I mean, because I'm intrigued, and I want to sort of come back and talk about this stuff in a little bit more sort of a broader, more philosophical way as to how there always seems to be a desire by people who push for these type of reforms to be able to just sort of, okay, we got the law, game over, and we don't have to worry about it anymore. And this story, more than many, it definitely tells how these things are really never quite done. But I was really interested. There's a couple of things I found really interesting about what happened, particularly with the SNCC, with the Student Nonviolent Coordinating Committee, and how John Lewis ended up getting pushed out by Carmichael, I guess it was at the time, by Stokely Carmichael. And I'm curious as to how much of it strikes me because, we had that moment where Bernie Sanders went up at Netroots Nation and tried to say, he was a member of the SNCC, and how we're seeing a new sort of civil rights movement, I think, grow up now, that the shadow of many people from that generation who fought for the Voting Rights Act, as the shadow is receding in some ways. And there seems to be almost I don't know how to describe it, maybe a lack of awareness of what took place at that time, but at the very least, I don't want to say a rejection, but a real desire to get out from underneath that shadow, because in some ways that has been inhibiting the growth of the movement going forward.
Well, it's really interesting. I mean, when I went back and looked at the passage of the VRA in 1965, I assumed that all the civil rights groups were on board, not just with the passage, but with the implementation of the act, because the act was so effective. But what I saw was that there were a lot of tensions within the civil rights community about the VRA. I mean, you had activists with SNCC who really believed this thing was not going fast enough. And really believe it didn't do enough, and it was too little, too late, and they had really stringent criticism of the VRA at the time, which I think history has proved that some of their fears were unfounded. But you have to remember that they were operating in these extremely segregated societies in places like Selma, Alabama, where you could and did get killed for trying to register voters, and so they wanted change as quickly as possible. And then you had other elements, that were preaching more caution, and we're trying to be more accommodationist. And Martin Luther King was kind of straddling both those lines, right? I mean, he was negotiating with the Congress and with Lyndon Johnson, but he was also trying to maintain his credibility on the street. And then what you see is that even though the VRA had an enormous impact, you still saw 5 days after the VRA huge rioting in Watts, and you still saw younger activists being very disillusioned with the pace of change and breaking off and becoming more and more radical. I mean, what happens is, the VRA is kind of widely thought of as the end of the we shall overcome church-based phase of the civil rights movement. And afterwards, it becomes a lot more radical, a lot angrier, a lot more hard-edged. People like John Lewis are basically pushed out of the civil rights movement in the late 60s and then come back in the 70s. And so what's interesting is there are all these tensions in the 60s, but then what happens is in the 70s and the 80s, those people who were civil rights activists, they start running for office, and they start becoming the beneficiaries of the Voting Rights Act. People like John Lewis start getting elected to Congress, and they start having a say. And I think there's in some ways, probably among some of the younger activists, there's a lack of appreciation for just how long and hard someone like John Lewis fought to try to democratize the country, to get elected to office, that this was not a change that happened overnight. This took decades of struggle. And so when people say that the civil rights movement ended after the passage of the VRA, I would argue that the election of people like John Lewis, the ability to get a President Obama, that this took decades of work, and this was a culmination in many ways and an extension of the civil rights efforts of the 1960s.
I know you've spent a lot of time talking to John Lewis. Like when he sees, and you write in the book about how he reacted, and to hearing the results of the Supreme Court case, which basically removed the pre-clearance formula in the Voting Rights Act. I mean, what is? I got to think, like, after whatever, I guess 50 years. The idea that you would see explicit steps backward, never mind resistance continuing, but like sort of successful resistance, has got to be incredibly, I don't know if demoralizing the right word, but
yeah,
upsetting.
I mean, I think it was heartbreaking for him. I mean, I saw him. I interviewed him a day after that Supreme Court oral arguments, where Scalia said that the VRA was a perpetuation of racial entitlement. And Anthony Kennedy, the supposed martyr on the court, said, well, the Marshall Plan was good too, but times change. As if the VRA was just frozen in time. It rebuilt Berlin, and then that was the end of it. And so I think Lewis was just astonished to hear these justices talk about the end of racial discrimination in voting when he has lived this for 5 decades. He almost died for this, but he's lived it ever since. And I really do wonder if the Supreme Court would have ruled the same way in the wake of Black Lives Matter. Could John Roberts have made the same argument about the progress we've made after Baltimore, after Ferguson, after Staten Island, after all these tragedies? I don't think that he could make this argument. In fact, I think if Roberts made that argument now, he'd be laughed out of the room. And so I think the whole environment over racial discrimination has changed so dramatically since that Supreme Court decision, and it's just underscored how bad and how unfortunate that decision was, and how heartbreaking it was for someone like John Lewis.
Do you think? I mean, did John Lewis have a sense, or do you have a sense that that in some perverse way, having an African-American president, having Barack Obama as the president, opened the door, at least in their mind, to make that ruling as well?
Oh, absolutely. I mean, it not only just opened the door to the ruling, I mean, John Roberts, basically, referred to that, prominently, but it also opened the door to all these new voting restrictions. So there's tons of parallels between the situation today and the end of Reconstruction. After the Civil War, we passed all these Reconstruction amendments, the 13th and 14th and 15th Amendment, and all these progressive whites and black candidates are elected in places in the South. It's amazing that you have black senators from Mississippi serving in Congress in the 1870s, and then there's this incredible backlash, and white Southerners do everything they can to not only through changing the law, but just through outright violence and fraud to take back political power, and they succeed. And the effort to restrict voting rights was never that violent and intense today, but it's the same thing where you see the demographics of the country slipping away from you. You see a new era of leadership emerging, and instead of reacting to try to court those voters, to try to change according to that new movement, you do everything you can to try to take power back. And that's what motivated the new voting restrictions. And I think that's one of the things that was motivating the Supreme Court as well. It wasn't necessarily pure partisanship, but it was this idea that the progress in some ways was an excuse to roll back these protections all of a sudden.
And that there was almost like too much progress. Like you don't want to.
I mean, and it was crazy that in his John Roberts, not in his ruling, but in his when he talks from the bench. I mean, one of the first things he says is, "Well, we've elected black mayors in places like Selma, Alabama." Not realizing that it was because of the Voting Rights Act and because of the continued protection of the Voting Rights Act that we elected these people. So some people look at the progress and say, that's great. It was because of the VRA. That's why we need to keep doing it. Other people looked at it and said, well, clearly we've made this progress. We don't need it anymore. And I think Roberts and all those guys took the latter approach.
Has anybody done any research, or do you have a sense of what we know now, right? I mean, there are numbers from court cases. We know now, like how many votes are going to be disenfranchised because of things like voter ID in Pennsylvania, and I think we have a sense of that in North Carolina. These are from court cases. We actually have like real numbers, right? I mean, we're talking about in the hundreds of thousands in Pennsylvania at the least. And do we have a sense of like, if you were to take these laws, particularly the ones from the pre-clearance states and counties, and they were imposed, let's say, 30 years ago, okay, 20 years into, let's say, 1980 or 1985 or 1975, had they been imposed at that time, how many more people would have been disenfranchised? I guess my point is that much of this is, look, you've got people who don't get driver's licenses. You've got people who, there are externalities that interact with a requirement for a voter ID that end up giving you the number of people who are going to be disenfranchised. How much people are working, whether or not they have the time to go and get a voter ID if they don't have a license, their ability to transport, where they're living. Are they living in the country or the city? Were they born, do they have access to their birth certificate? All of these factors. I mean, is there a sense that, how people are impacted now versus then and vice versa?
Well, someone was asking me this question recently: what would the U.S. have looked like if we didn't have a Voting Rights Act? And I think the U.S. would have looked like apartheid South Africa. I mean, that's what the U.S. was, practically speaking, before the VRA. I mean, we were not a democracy, and we would have had a tremendous amount of racial tension and violence resulting in the 1960s if we didn't have a VRA. So I mean, it quite literally saved American democracy passing this law. And Section 5 of the Act, which was rendered inoperative from the Supreme Court, was the most important part of the Act, because what it basically said is, by forcing those southern states in particular to have to approve their voting changes with the federal government, it said that they couldn't just disregard the VRA like they had disregarded the 15th Amendment and all these previous laws. So, I mean, that's what essentially led to compliance with the law. You had to comply with the law because you had to approve your voting changes beforehand. And if you didn't comply with the law, your voting changes just wouldn't go into effect. And so that's why we saw that, Section 5 of the law, it it led to 3,000 voting changes as a conservative estimate being stopped. Those voting changes, if they had gone into effect, would have burdened millions of voters. So I think the answer to your question is, millions of fewer people would have participated in the political process if the VRA was not able to stop the kind of efforts that we're seeing today.
And we should say that's also in relationship to a smaller population. But I want to, because you just made a great point that I really want to make sure that I want to make it explicit. I want to make sure people understand this. You have a constitutional amendment that basically says you can't impose these laws that are going to disenfranchise minorities, and they were completely ignored for almost 100 years.
Almost 100 years.
And so what the Voting Rights Act did is it created an apparatus to make sure compliance, that basically enforced compliance in a way that was enforceable. And so I just want to make that clear to people as to why we need it. And I also want to add that lest people think that, this was just about the South. There were counties in New York and I believe California that were also covered under the Section 5 or the formula. Is that right?
Yeah. I mean, it didn't just apply to the southern states. It was expanded over time. So, for example, it gave protection in 1975 to language minority voters, Latinos, Asian Americans, Native Americans. So that led to coverage in places like Arizona, parts of California, parts of New York, parts of the Dakotas. It led to bilingual ballots being distributed all across the country. So the VRA, as I mentioned earlier, the voting age was lowered to 18 as a result of the law. So the VRA, helped all voters. It didn't just help one segment of voters. I think that's the most common misperception about the law, that it was only intended to help one group of people, that it only helped one group of people, that it was special preferences for one group of voters. And that wasn't true at all. I mean, it helped such a broad range of voters, particularly those voters who were historically disenfranchised. But it also helped a much wider community of voters, because what happened is you had, in many situations, minority voters and progressive white voters joining together to elect much more progressive candidates across the board. So it led to, America being a more progressive country at every phase of government. Now, obviously, there's been a very significant backlash to it, and you've seen conservative officials take office in reaction to the VRA all across the country, but I don't think we can downplay the fact that you've seen a much better representation across the country as a result of the VRA.
All right. Now, Ari, I know you have to go because I know you got a lot of other interviews to do today, but let me just ask you this last question. I mean, because we've talked in the past about the idea of Congress actually stepping up, and John Roberts sort of naive, if we take him at face value, or disingenuous call for Congress to simply create a new formula and we'll sign off on it. But there's been attempts to bring it up. It's everyone knows it's not going to happen with this Congress. But in terms of any attempts to use, I think is it Section 2? The opt-in, the opt-into or the fall back into, or whatever you tell me what the phrase is, where finding by the Justice Department that some state is attempting to infringe upon the rights of certain people to vote, sort of brings them back into a pre-clearance status. Just tell us what's happening on that front.
Well, that's just very difficult to prove. I mean, that's like the absolute long shot angle of the VRA. I mean, it was hard to prove intentional discrimination in 1965, and it's much harder to prove today because most legislatures are smart enough not to say we want to prevent Black or Hispanic or Asian Americans or whomever from voting. In Texas, there was a ruling in the voter ID case of intentional discrimination. That ruling is being appealed. Pending the appeals process, we'll see if Texas could get bailed back in. But I think it's going to be very difficult in North Carolina and these other states where there's lawsuits to prove intentional discrimination. So I think people are relying on Section 2 of the VRA, which applies nationwide, and you just have to show the effect of discrimination. But that's even hard to win cases under, because now the burden of proof is on those people who are facing discrimination, as opposed to Section 5, where the burden of proof was on those states to prove that there wasn't voting discrimination. So the whole burden of proof has shifted. These are very long trials. The outcome is very uncertain. And so we're on the 50th anniversary of the VRA, but lawsuits to challenge voting discrimination are very uncertain. The Congress won't do anything. So this is really a rallying cry moment where people have to realize that this law is being eviscerated, and we got to do something about it soon, or else there's going to be a lot of problems at the polls going forward.
And we should say it's not enough to say that, well, they've been explicit that they wrote these restrictions to inhibit Democrats, right? I mean, because that's actually okay on some level.
Yeah, I mean, the court has not weighed in about the role of partisan politics here because, there's basically the argument they have to make is, under the VRA, you have to say, well, even if you tried to just disenfranchise Democrats, if African Americans, Hispanics, Asian Americans, et cetera, are overwhelmingly Democratic, then what you're doing is you're dealing with a de facto disenfranchisement of minority voters, which is illegal under the VRA. And there's this whole debate among law professors about whether the focus should be on ending racial discrimination or ending partisanship. And to me, it's a theoretical conversation that I don't put much stock in, because to me it's the same thing. I mean, despite what the effect is, the fact is that minority voters are disproportionately affected by these laws, whether it's about partisanship or whether it's about race. It doesn't really matter what the intent is. I don't think it should matter what the effect of it is. And so, to me, I'm not separating out the two. I'm not trying to understand the motives of what the North Carolina legislature is doing so much as I'm just trying to show what the law is actually leading to.
Okay, so lastly, the disparate impact case from that we had in Texas on the Federal Housing Authority, where essentially there was a case about whether or not an authority could provide loans, and it ended up that they were not providing loans to minorities, but they had their own justification that had nothing to do with that. But because of their program, it had disparate impact. In other words, it had discriminatory outcomes as opposed to intent. You didn't have to prove the intent. How is that going to help?
It should help. It should help because people who are now trying to narrow Section 2 of the VRA are saying the same thing, that you have to prove the intent of discrimination, not the effect. This was actually the argument that John Roberts made as a young lawyer in the Reagan administration, and so he very could well make it on the court again today. And in the fair housing context, at least Anthony Kennedy said, no, you don't have to prove intent, to just the effect of discrimination. And that's huge for the VRA going forward, because I think everyone believes that the constitutionality of Section 2, or at least the interpretation of Section 2, is going to come before the Supreme Court in the not-too-distant future, either from North Carolina, Texas, or one of these other states. And if the Supreme Court takes a very limited view of Section 2 of the VRA, that will limit the only other important tool that we have left here. The law is already half eviscerated, and that would basically completely eviscerate it. So, the fair housing case should be a good precedent for the VRA, but we just don't know going forward. All
right, and I'm going to do this because I think your book is so important, Ari, and I think the work you've been doing on this for the past now 5 years is so crucial. We are going to run. This is going to be the first contest we ever have, maybe the second. The first 10 people who email us with their receipt for buying Ari's book, which is available now, right? We've got a link to it on our we've got a link to it on our blog. Give Us the Ballot, The Modern Struggle for Voting Rights. We'll get a free, brand spanking new Majority Report bumper sticker suitable for a computer, like Noah has put it on his computer, or on Mila put one on Saul's back the other day. So it will stick to just about
very
anything.
Exciting. So this is the first Majority Report bumper sticker email contest.
Email? Well, it's not email contest. It's like a book sale contest.
Book sale contest. Okay.
So just email us.
If this doesn't push it to the bestseller list, I don't know what will.
Email your receipt to majorityreporters@gmail.com, and also give us your address. We will send that out forthwith. Ari, always a pleasure. We will put a link to your book at majority.fm. Thanks so much for coming.
Thank you so much, Sam. I really appreciate it.
All right, bye-bye. Great stuff from Ari Berman. Always great to talk to him.